Welcome everyone. I'm your host, Amy from Breathe. Lovely to have you join us today. I'm really delighted to welcome you to this mental health and employment law focused webinar. We've got a really good session coming up, and we are joined by two brilliant people today. We've got the amazing Tessa Robinson, Senior Associate Lawyer at Outset, and one of our most amazing partners, Natalie Ellis, Managing Director at Rebox HR. So to kick things off, they will introduce themselves, and then we will do a little bit of housekeeping before the full session. So Tessa, over to you for a little introduction, please.
Of course. Morning, everybody. I'm Tessa. I'm Senior Associate Lawyer at Outset. I scarily have over 10 years experience now in employment law and all related matters. We specialise in discrimination cases at the moment, and it's really rife, which is why it gave rise to this subject today. But yeah, looking forward to speaking with you all today.
Thank you so much, Tessa. And Natalie, over to you.
Okay, so I'm Natalie Ellis. I am a HR professional with nearly 20 years experience. Started my career in consultancy around 2016, 2017, before starting my own company in 2020, which is where I am now. So yeah, and we specialise giving employment law and HR advice to small businesses throughout the UK.
Perfect. Thank you so much, Natalie. And welcome. If anyone hasn't been to one of our webinars before, if you don't know about Breathe, we are a HR software company. But this is just a little feature that I wanted to share with you about staying on top of employee burnout. This is something that we offer, so it's good on keeping track on your employees and maybe when they need to take some holiday. Natalie has some lovely things to say about this. So Natalie, I'll just pass over to you.
I think, to be honest with you, it's been really good for us to utilise, not just as a HR consultancy, but to be able to deliver a bit more proactive advice to our clients. And one of the things, feedback-wise, that we've received about the burnout indicator itself is how useful it is. We're finding that, especially with people working from home, that people are probably saving or banking their holiday because they're at home more often. They feel like they're not working as much. It may be a psychological thing, I'm not sure, but for some people, it just seems to be a case that we're seeing more presenteeism. So a lot of feedback around the burnout indicators are actually, we haven't had such and such off on holiday for a while now. We think it would be really good for them to take a break and make sure that our people are getting their adequate breaks in. So if there's any other HR consultants on the webinar this morning, it's a really useful tool for you to be able to share that with people, and the feedback for us has been brilliant on that.
Thank you so much, Natalie. Cool. So to kick things off, we just kind of want to get a feel for what people are experiencing at the moment who are joining this webinar. So you should be able to see a poll right in front of you now. The question is, what is the biggest challenge your organisation faces regarding mental health in the workplace? You can choose from A, B, C or D. If you could start submitting your answers, that would be brilliant. And we'll have a brief conversation just to get a feel for what your thoughts are. But Tessa and Natalie, is there anything you'd like to add to this?
I think before the call, we were just talking about how it's such an individual topic, and all the situations that kind of face people in the workplace are so specific to each individual with that mental health issue at that time, that actually all of these are probably issues that people are going to face at any given time, and different organisations will have different pressing needs. So it'll be really interesting to see which ones overall come out sort of as employers' biggest issue. It'll be really enlightening.
Yeah, definitely. Cool. I can see we're about 60% of people who have answered. So we'll just wait for a few more and then we can discuss that before Tessa and Natalie kick us off for the session. I can see someone saying they can't see the poll. Hopefully, if you just wait for it to load for a second longer, because the poll is running for most people. Perfect. Okay, I think we've got a good amount of answers here, so we will have a quick look at the results now. Okay, here we go. So Tessa and Natalie, it looks like it's pretty close, to be honest, but the final one, balancing legal requirements with employee needs, seems to be the winner here. Would you like to have a little conversation to share what your thoughts are?
Yeah, I mean, this is something we see all the time, obviously, as lawyers, people wanting to do the right thing by the law, but actually the employees' needs sometimes shout louder, and it's finding that fine balance. And we do have a few examples later on in the session today which go through this and how actually you can balance the two and setting the parameters to make sure that you're not overstepping the mark and actually going outside the realms of the HR role or a manager role, and balancing the organisation's needs against that of the individual. So yeah, not surprised, to be honest, based on the examples we've worked with clients. And training, I don't know if Natalie finds the same, but training is something that lots of organisations don't put into place around this. So it is just difficult for managers to have the conversation. It's not from a lack of wanting.
No, I completely agree with that. And when we're trying to give the best advice that we can, and I know that my fellow HR professionals in the room will be thinking exactly the same thing, is that we can give the advice and it's completely up to that client if they decide that they want to take that advice or not. So it's being able to be objective at the moment. And when I'm giving advice to my clients, what I'm finding is that they're saying, Natalie, I'm just not comfortable with addressing XYZ issue. And we find with a lot of managers, they are what we class as accidental managers. They've probably been very good at their jobs and then been promoted within, but they've not necessarily been given the tools or knowledge to be able to manage a team of people when they come with very individual personalities and very different expectations. So it's really important that managers get to know their people, first of all, so that they can know the signs of when these sorts of issues start to creep in. And you can only do that through training and teaching them how to actually spot these signs in the first place so they can manage it more effectively. But sadly, the investment just doesn't seem to be there. And I'm seeing that in both the large clients that I work with and the smaller businesses too.
Thank you both for sharing this. I think now we can get going with the big topic in hand. Just one more thing, you might see there's a reactions button on your console as well. So thumbs up, faces, hearts, all sorts. So please do use those so we can see where you're engaging with the content when possible. Wonderful. Tessa and Natalie, over to you, please.
Lovely. Before we get into the detail of certain situations, and we're very much going to look at some neurodiverse conditions because unfortunately neurodiversity and mental health go hand in hand in the workplace. I wanted to really look at what equality, diversity and inclusion means, because this underpins how you approach these tricky issues in the workplace. And I don't think there's really a true understanding of the meaning of each of these and how you can build and create the workforce and that environment that you want to build. Equality is not about treating everybody the same. This is what we hear time and time again. Equality doesn't mean doing that. It's about making sure you remove the barriers that are in place to ensure everybody can access the same opportunities. So you've got to do something proactively rather than just saying this is our policy, that's how we implement it. Diversity, again, you find time and time again, it comes out through recruitment procedures where you do try and recruit from diverse backgrounds, different places, different sources, but it ends there. And actually what you need to do is value those differences between people. It's not just about ticking the box so you can show on a questionnaire that you've got a diverse workforce. It's really about celebrating that diversity and those differences. And equality and diversity without inclusion is nothing. You won't create the right environment to really tackle neurodiversity, mental health, stress in the workplace. Inclusion is really the measure of how safe and welcome people feel in their environment. It's about the effort that you put in And if you do create a diverse, equal, inclusive workplace, you will find the conversations are so much easier to have with individuals because they're more open with you. And I always put this quote in at the bottom when I'm talking about equality, diversity and inclusion. You have to create a workforce process and a workforce environment that makes people feel not just invited to the party, but also asked to dance. And that's the diversity and inclusion, and really making people feel that everybody is valued regardless of their background, any disabilities they have. So if you don't have the inclusion part, it's pointless dealing with the equality and diversity. I don't know, Natalie, how you feel with your clients around all this and whether you see it works, it doesn't.
First of all, you know how much I absolutely adore that quote, because it explains it so simply as to how we should be looking at things. And as HR professionals and companies, what they tend to focus on is the actual policy and the tick boxes of these checklists of how do we include people. Okay, step 1, do this, step 2, do that. It's not as simple as that. The strength is actually by knowing your workforce, your teams, and understanding how they work together. It's about having a very clear idea on what the difference is between those 3 things. Because if we go on to any other HR style webinar, you're going to see equality, diversity and inclusion bundled into one thing, which is possibly giving the wrong impression of what that actually looks like in practice. And when we're advising or when we're in our meetings with managers and things like that, they're thinking, well, how do we get more diversity into our organisation? It's actually by looking at what that looks like practically, rather than looking at it as a tick box exercise, like we've seen with what we call the positive discrimination recruitment exercises through, and we still get, I mean, we've been asked a number of times about how do we get more diversity within our organisation. We saw a huge case with the Metropolitan Police where they were trying to get involved in more specialist community officers, for example, and it backfired on them massively, and that case went on for a long time. So there are ways and means of us being able to learn from what the cases that we've seen and what has happened historically, so that we can then understand how our approach should be practically, whilst balancing the needs of both the employee and the organisation.
So with that background in mind, and as much as I want to look at this as practically as possible, I did kind of just want to highlight the framework of how it does interact with employment law, just so as we go through the practical ways to deal with these issues in the workplace, you'll see how you naturally eliminate the risks associated with the employment law protections that people have. So in the workplace, it obviously shows through people having protected characteristics, neurodiverse conditions. Menopause is a big one, whole topic in itself, and mental health, which again is wide and diverse. So equality, diversity, inclusion, it's so wide, as Natalie was saying, lots you can try and pigeonhole it into one webinar. It's not. It's probably about a week's worth of webinars and discussions on that topic at least. And then employment law, the main one it interacts with for obvious reasons is discrimination and implementing reasonable adjustments. So this is where you create the level playing field with people with equality and supporting people without them having to ask, and that's inclusion. So that's the point about inclusion. If you're making a reasonable adjustment, legally it's actually on the employer to implement those and come up with reasonable adjustments. You shouldn't put the burden on the individual. And if you put the burden on the individual, you're automatically not going to be dealing with the inclusive part of EDI. And then diversity, it's all about recruitment, promotion, and making people feel safe so they can reach their own potential. And then that impacts on everything, your performance procedures, your disciplinaries, your appraisals, career progression. It really impacts the entire work-life system, essentially. Don't know if, Natalie, anything to add on the framework, anything you feel?
I think this is probably the area that confuses employers the most. So when we are looking or advising on cases, we'll ask them what the protected characteristics are of the individual, because naturally we need to know what we are kind of going into. And when you're looking at trying to explain this, the amount of people that just don't know what that looks like is quite scary, because they will call and they will say, well, actually, I just want to get rid of this person, but not have a really valid reason why. And without them understanding these key points, then they're putting their organisations at risk. And as you would quite likely highlight, Tessa, is that these claims can be uncapped, which means the award can be uncapped, which is big money. Taking things like this seriously, to be able to take measures to protect themselves whilst doing right by the organisation. And it's not just a case of having the right policy in place, it's knowing that information. So one of the cases I'll give an example briefly of that I've handled in the past 6 months, anonymised of course, is a situation where an employee has claimed mental health issues throughout. There's been no medical evidence of that mental health condition. There's not been any indication of it previously. This person is long serving. And the employer has now said, I am too scared to have a conversation or bring anything up to that employee because I'm going to say something wrong, because they will have their own opinions on things. The person has put up barrier after barrier with not going to occupational health, even though that's been offered at the cost of the company on multiple occasions. They've offered EAP, you name it, they've offered it to the employee. Now that barrier has continued, so the employer now feels that they're stuck with a disruptive employee that they feel they can't approach to even ask them to do a piece of work for them. So there is a series of things that we're having to try and really coach managers through to be able to get to what we need to be. And there's often this, right, we're hiding behind HR now. HR, you have the conversation. The last thing somebody who is having mental health issues wants to do is to speak to a complete stranger. So the more we equip, and I will keep coming back to the line managers, the more we equip them with the knowledge to be able to spot the signs and nip it in the bud, first of all, you are doing right by your employee, but you're also doing right by the business. And that's the balance that they really struggle with.
Yeah, definitely. Completely agree with that. And I've just seen there's a couple of questions. So one is, sometimes you see E as equity, which is correct. And what's the difference? So normally it is equality, diversity and inclusion, but in reality, equity, it's not a bad way of looking at it in reality, because it's creating that equity in your workforce. So it is equality, diversity and inclusion, but equally it does sometimes get interchanged with equity. And it's basically just about making sure everybody has equal access to all the opportunities in the workplace. And then there's another one that's come in, which I just want to highlight now because we'll cover it later on. And this is a situation that employers find time and time again. So the question was, how can you make a reasonable adjustment if a neurodiverse employee themselves does not know what would help them at work? And I'll come on to that because we've got some good resources and ways to find out how those specific neurodiverse conditions and the individual nature of them. So bear with us, we will go through that later on in the session. So EDI and disability. So this is obviously the main place it comes up in the workforce. And I wanted to just briefly touch on neurodiversity and mental health. The main question is, do they always have a disability because they've got a neurodiverse condition or they're suffering from poor mental health? I'll come on to a couple of specific examples again, but it's safer to assume as an employer that they do and investigate, because by the very nature of having those open conversations and speaking to individuals, you're offering support. And that support may transpire into a reasonable adjustment later down the line if they do have a disability, but you're never going to be on a bad platform if you start the situation and conversations by just simply being open and offering support. I don't know, Natalie, do you find that's helpful or there's a resistance from employers doing that?
I think it's because generally employers don't know how to manage it effectively. So because I deliver a lot of training around these elements to be able to make sure that they have the tools that they need. There's also the Breathe Learn platform that my clients use regularly. And on that platform, it does have different modules on there that do cover what the differences are and how to effectively manage mental health at work. So if you're not using that already, that's definitely something that you could possibly make use of. There is this assumption that people have a disability. If they automatically say, I have a condition or I have mental health issues, employers will automatically assume that it is a disability because they're not sure of the differences between those three things. We're seeing a lot more cases of neurodiversity in workplaces. So I have autistic members of my family, my immediate family, and they were diagnosed later on in life because they were struggling at work and couldn't really understand themselves. And the only way that you're going to be able to get that information from the individuals is by having that open and transparent conversation in the right way. So, for example, my husband, when he was diagnosed, he was in his 40s. And he thought, well, why should I be doing this? But I don't understand how I can tell my employer that I need to do the right thing in what I'm doing, and I'm not able to complete X, Y, Z because it doesn't work that way for me. If you've met one person with autism, you've met one person with autism. It's very individual to people. So you're not going to meet any people that are the same. So it's always safer, like you say, to assume that, yes, it could be treated as a disability, but you have to have that relationship with that person to be able to ask those questions comfortably. And a lot of the time, we often work in silos. We've got our own work to do. And it's no different when we're working in large teams or small ones. But the advantage you have as part of smaller teams is that actually you're more aware of each other's behaviours more often. So you would know if somebody's having an off day or somebody isn't quite they're not quite themselves. That should be the indicator to say, actually, let's have a coffee and a chat. It doesn't have to be formal. You can just ask how that person is doing, but really mean it rather than it just being a passing, you're right, mate, because it just doesn't really give you the context for you to be able to have something tangible to work with.
Very interesting. I'm just seeing some questions coming in as well from Gemma and Hayley, and both the questions we will cover in the subject and throughout the course. So hopefully we'll answer them. But if we don't and you have something further, let us know. Just pop a further question in the chat. But yes, we were going to move on and then start to look at neurodiversity. So as Natalie was saying, this is such an individual issue. So one person with autism, like she said, it's one person with autism. One person with ADHD, it's one person with ADHD. So you can't assume that because you've met one person and the support you gave that person is going to be the same for everybody. And I kind of wanted to I've chosen ADHD as the neurodiverse condition to take a deep dive into because it's becoming so prevalent. It's in the press. Awareness is, well, it's just becoming so much more to the forefront of people's minds. Lots of celebrities have disclosed that they have been diagnosed. I think Justin Timberlake was one of the most recent ones. And when you look at how an individual gets diagnosed as an adult, you can really start to see how it interplays with the legal definition of disability under the Equality Act 2010. So to be diagnosed with ADHD as an adult, the symptoms and the traits that they present must have been present from the age of 12. And it really is not a case of just going to the doctor and saying, I'm a bit disorganized, I've got ADHD. My husband actually got diagnosed with ADHD 3 years ago after a couple of career changes, losing his passport all the time. He's actually on to his 6th loss of passport in 5 years. So he's got all these symptoms, but the GP, as your first port of call, will go through in detail, and you have to evidence where these symptoms are, whether it's at school reports. So it has to have been there for a long, long time. And it has to be severe enough to interfere with work and how the individual gets on with other people. So again, like my husband, he had a career change. That's so typical with somebody who has ADHD that's been undiagnosed, because they struggle. They haven't had the support put in place with them because they don't have the diagnosis. And then you can really start to see, if you think about the basic definition of a disability, which is a physical or mental impairment that has a substantial and long-term negative effect on your ability to carry out day-to-day activities. Simply by getting the diagnosis, they're going to have ticked that definition. So in 90% of cases, people with ADHD are likely to be classed as disabled, but it is a case-by-case basis. Remember the but-for test. So a lot of people with ADHD go on medication to assist them. But for that medication, they've still got ADHD, they still have those impairments. And simply by the fact they take the medication does not make them disabled. That's a tried and tested employment law principle, so remember that. But having said that, under the guidance, the Equality Act 2010 guidance, it does say that a person should be reasonably expected to modify their behaviour to reduce an impairment. And if they can make small, and we are talking small modifications to reduce their impairment, they may not be classed as disabled, because essentially how they behave and how it affects them on that day-to-day basis no longer has that severe enough effect to interfere with their day-to-day activities. So there is a slight expectation on an individual to engage with the fact they have that disability and, for want of a better way of putting it, helping themselves in the workplace. It is a two-way relationship. But it's really important to note that actually avoidance strategies, which again are so common with people with neurodiverse conditions, that is not a reasonably expected modification. So the very fact potentially somebody with autism avoids presenting and doing BD or going networking, it's not a reasonably expected modification to their behaviour. Or likewise, if somebody who has an ADHD trait where they impulsively interrupt people, if they simply stop talking in a meeting to reduce that impairment and that social embarrassment, that doesn't fall under this category. And it's very, very wide. So it's just worth I thought that was really interesting when we're going through that diagnosis process with my husband, seeing the evidence that has to be provided to meet that diagnosis, how it very quickly interacts with the definition of disability, and then how those behaviours manifest themselves day to day in the workplace. We will touch on how, if people don't have a diagnosis and how you deal with that, but you spot traits. We'll come on to that a bit later. But I did just want to highlight that actually, if it's that difficult employee who maybe you've started your performance improvement processes with them and they have suddenly said, oh, I think it's because I have ADHD. From a purely legal perspective, and I'm not necessarily suggesting you have this as your HR conversation with your employee, but if they haven't got a diagnosis and they can't evidence that, and later down the line they do try and bring a disability discrimination claim against them, we often, as the first line of defence, say we don't admit that that individual has a disability. The burden of proof does lie on that individual. But then as an employer, if you engage in that conversation and you say to the individual, okay, why do you think that? What are you finding difficult? What support can we give you? Even if they're playing on the fact they think they have ADHD, you're providing support. So you can say to that individual, well, we've given that support that you wanted. What more do you want to do? And it's making people realise that these traits aren't excuses. It is that two-way relationship. But it's a way sometimes to help that individual who you suspect is playing on the fact that they've become aware of neurodiverse conditions and they don't actually have one. There are some uncouth people out there, shall we say. I don't know if, Natalie, how you see that in the workplace playing out. You're nodding.
Yeah, absolutely. I think it's really, I've just seen in one of the comments that a line manager has followed protocol to assist a subordinate with their mental health. However, the employee felt offended by their approach and now refuses to be around their line manager. And that's really sad to hear, but I'm hearing this on a daily basis. The issues that we have is that we're finding that, I mean, I won't beat around the bush, I'll always be completely honest with people, is that employees are much more aware of their rights these days. HR is a really tough gig right now, and we can only see that increasing as we move through people becoming more aware of things. It's not that employers want to take advantage or anything like that, but it does feel commercially that it's very, very difficult for employers to get it right, even there's no malice involved, or that they are approaching it saying, actually, I'm concerned, I have noticed XYZ going, do you want to talk about it? Do you need some support? And automatically, if you've got a disruptive employee, you will find that they will become offended immediately by these sorts of things, because unfortunately I'm seeing an increase in serial claimants coming through, where they essentially make a living out of these sorts of things. So they will throw everything and the kitchen sink to be completely as disruptive as possible, putting the employer in a corner going, oh my gosh, I didn't mean anything by this, and now I can't undo it. And then you end up signing a settlement agreement, or it goes to tribunal, and then, that employer has to live with that experience forevermore. And it could be through something completely innocent. I really feel for managers that have to go through that, and employers that are paying out unnecessarily because they feel they have no choice but to do so. So if anybody has experienced anything like that, I am really sorry for you. But having the right advice before you have the conversation is so important. If you feel uncomfortable, or you feel that actually I don't feel equipped to have this conversation, just the last thing you should do is just wing it. What we do as HR professionals, and in Tessa's capacity, is to make you comfortable with the uncomfortable. So whether that means us being present with you or supporting you to guide you through the process is absolutely essential to keep yourselves out of what we call the HR hot water. But yeah, I really feel for that person who made that comment.
Absolutely. And I would say the more you actually tackle these issues head on and you offer the support, like the comments coming in, we've done everything more, but the individual's still using it as an excuse. Stand firm. Know actually that you have done everything that you could do for that individual to support them. And this is about having your EDI strategies in place. You have policies, but you breathe them, you live and breathe them, and you have this environment where I always say to a client when I'm defending a disability discrimination claim, if I can hand on heart say to a judge, what more can my client possibly have done to support this individual? You are going to be in a good place to defend that claim, regardless of what that individual says. And we Natalie's right, we've absolutely seen a rise of people just having a go in tribunals and blaming conditions, and it's not an excuse. And I think as employers, you just have to, and this will come, the more you deal with these issues, the confidence grows. And it's having confidence in the process you followed, the support you've offered. And then actually, as a manager and a HR professional, making that difficult decision. Don't be afraid to make that decision that you feel is right. So if someone's at the end of that performance process, you've done everything you could, just because they're shouting, I've got a disability, doesn't mean they're going to succeed in their claim. And this is where we can sometimes apply for strikeout applications early on and put pressure on through our legal means of the defence to actually try and get either a strikeout or an early settlement, because basically if they get a solicitor on the other side, they will see that we are going, well, what more could we have possibly done? We've done everything we could reasonably do as an employer. And if you're in that position, you're going to be in a strong place. And it's just having that confidence, and it will come over time.
It's having that confidence in the process, isn't it? And a lot of people, the more they're aware of it, and yes, we know policies are bedtime reading, but they are there for a reason, because they set that expectation on both sides, how people expect to be managed and how they are managed. So I understand that there's plenty of people that get confused or aren't very clear in terms of, oh, that person is disabled, therefore I can't have a conversation with them about their performance, which is categorically not true. If it is evidenced and it is constructive and you're not doing it because of the disability, then it makes, you're covering yourself. And a lot of people don't realise that, and they are still very walking on eggshells, so to speak, around these conversations. But it also impacts on the rest of the team as a culture as well. So we have to be really mindful if we are treating somebody like that because of X, Y, Z. Yes, you take it into account, but you don't put them on a pedestal, because that it doesn't help integrate or create that inclusivity with everybody. It's actually isolating people, which, again, Tessa, you'll say, is a claim in itself. So it's really, you have to have that balance. And as I always say, if you don't know what the right advice is, make sure that you seek it out before you even start a process. If you are unsure, we'd rather you call us a million times and we get it right the first time, rather than going, oh, do you know, I did say this to the employee, and you're sat there, Tessa and I, like, no, why did you do that? But you can't undo it. And what we have to remember is that whilst Tessa and I are speaking about some really real, quite scary things, is that remember that people problems are always fixable. You can always find a suitable resolution to the issue that's at hand. So have confidence in yourself and your own capabilities, and know the process, and everything should work out well for you.
Thank you both. Just before we go on to the next slide, a couple of people have asked a very similar question. So one is, does the employer have the right to ask the employee for proof of the diagnosis, e.g. a doctor's certificate? And likewise, do you have to provide a proof of records, e.g. doctor's note?
Yeah, very, very good question. When I advise clients, I basically say, do it from the supportive point of view. So if somebody goes, I've got ADHD, I've been diagnosed, ask whether they're willing to share those documents with you as part of the process and referring to occupational health, so you can understand how that diagnosis affects that individual. So you're doing it from that supportive point of view. An individual can absolutely refuse to provide those documents, and we see it time and time again. And that's where we start to get suspicious that they don't have the diagnosis, because most people who have shared they've got the diagnosis wants their employer to understand. So I wouldn't go, well, prove it to me. That's where we get to when I was talking about doing the legal defence. It's on the individual to prove the burden. But if you've requested that information and it's not forthcoming from the individual, you can only go on the information they've told you about how it affects them. You can only go on the information they provide. It's just about making the right inquiries in the right way to have the conversation. So yes, request it, but do it through that positive mindset of, we want to understand how this affects you individually. If you'd be willing to share more information on all your diagnosis, so we can see which traits in particular might affect you in the workplace, we can ask occupational health and discuss reasonable adjustments specific to that. So it's doing it very much in that supportive method.
I think it's interesting that HR will there's still this kind of culture, as this bias culture, as say, no, it's fine. We'll take what we have on that medical note or that occupational health report or whatever that, doctor's report, and whatever that looks like. The point that you made, Tessa, about occupational health is so important, yet it is overlooked all the time. And what we have to remember is that occupational health work on the employer's behalf to identify any reasonable adjustments, if any. A doctor's report doesn't necessarily give that. They will only give the information that the patient is prepared to provide. And a lot of people don't know the difference between the two. It's much better value for money and a lot more constructive for businesses to look at an occupational health professional. Now, HR aren't medically trained, lawyers aren't medically trained, Breathe aren't medically trained. What we do is we always seek that evidence piece around what does it look like, what situations should we avoid, and also what can be done to put the reasonable adjustments in place. And I had a client with an employee who had dyslexia, and she came in with a really long list of adjustments that she wanted making. Now, the employer didn't phone me. They should have done. They didn't phone me, and they basically put in nearly £16,000 worth of adjustments just upon what the employee had said. 2 months later, they phoned me and they said, Natalie, we're still having these issues with this employee. We've given her everything that she needs. And I said, well, hang on a minute, what medical evidence do you have that says that she needs those adjustments? Because again, dyslexia, it translates differently with different people. So when I'm going through this with them and they've said, oh, we've spent all of this money, the employee's still not performing. And then the employee has then sued the employer because they've put in the wrong adjustments, and she won. So we can come from a place that is supportive, but we have to be mindful that we're putting the right support in and not assuming, because assumption in itself, even though you feel that you're being particularly helpful, actually is not, it's not the best way of going about things, and it will cost in the end. It's not always about cost, but in the current situation that we're in, there's a lot of businesses that are struggling right now. You do not need to be spending unnecessarily on things that employees don't need, first of all, but secondly, on expensive claims that could come through under the discrimination element, where you're then handed over to Tessa and then Tessa has to sort it out for you. So it's one of those where we have to be really, really careful not to assume and not to put the wrong adjustments in.
And that's a perfect segue into the next slide. Don't self-diagnose individuals. We're not medical professionals. You might spot traits, but it's all about offering support regardless of whether they have a disability or not. As I keep saying, if you offer this support, but you do it through following your proper processes that you would always do, you're going to be on safer grounds rather than just diving in yourself. So if a disability is disclosed, or even if it isn't, take time to understand how it affects that individual. And as Natalie said, send them to occupational health. You would do for any physical condition, so why wouldn't you for a mental health condition or a neurodiverse condition? They will give you the starting point for reasonable adjustments. We are finding, sadly, that occupational health is slightly shirking away from being helpful with specific reasonable adjustments. But I've added a link to ADHDuk.co.uk as an example. They have a list of reasonable adjustments that employers can consider that may be suitable for people with ADHD. So this is about, again, having that conversation with the individual, going, okay, we're going to talk about reasonable adjustments, but we want to make sure they're suitable for you. And the employer leads the conversation and they're specific to that condition. They're not just generic adjustments. And other organisations have similar lists for different neurodiverse conditions, menopause. There's loads of information out there. So I just kind of wanted to draw your attention to actually that gives you a framework to start to have the conversation. You don't have to guess. You don't have to put the onus on the individual. Use the evidence and the resources that are out there for you. Access to work, for those of you who don't know, just very quickly, they basically provide funding to give access to noise cancelling headphones, for example, or noise cancelling partitions between desks, or software that might suit people. You have to self-refer as an individual, but as an employer, if you've brought that resource to the attention of the individual, you're going to be, again, on the forefront looking supportive and inclusive. And just remember to review everything regularly. Just because you've done it once, that's not the end of the journey. You need to keep checking in with the individual and making sure that they're okay, because neurodiverse conditions, as I said, they're often coupled with a mental health condition. And I'm very conscious of the time, like it's such a wide topic. So we'll move straight on to mental health and deep dive into this, because there's a couple of good examples here, which kind of interacts with the questions that people have asked. Never make assumptions about people with poor mental health. It's a huge, huge rise in mental health issues post-pandemic. It's really coming to the forefront, where actually the brain has just given up with people. They've gone through so much over the past few years. And everybody has difficulties in their life. An individual may not recognise their own poor mental health. And this is where the issues become really, really tricky. If they recognise they've got poor mental health, it's an easier and more open conversation. And the examples here are two real life case examples that we've advised upon over the past 18 months, 2 years, where the individuals didn't recognise that they're suffering from an acute mental health failure. So the first one had a phone call. This took a year to resolve this case. It was really, really difficult. But an individual essentially harassed their manager by sending hundreds, and I mean hundreds and hundreds of Teams messages, WhatsApps, emails, basically undermining their strategy for their department in the workplace. At that point, she did not talk about poor mental health. You could kind of see that this was really odd behaviour. And they had made the decision to suspend before they called me. That was a knee-jerk reaction to stop the issues going on in the workplace because they were worried about the damage that she could do. And to be honest, that decision sparked the entire next 12 months of difficulties they faced. The individual obviously felt very affronted that they had been suspended, and then they admitted that they had poor mental health. They disclosed that they had difficulties in their childhood, and they were signed off sick. She refused to engage in any discussions around the disciplinary that they'd instigated. She refused to go to occupational health. She continued sending the managers harassing emails. And when I mean harassing emails, I mean pages and pages, 3-4 a day. It was constant. And just refused to actually engage in a normal procedure. It was very irrational behaviour, and you could very much see she was having a mental health breakdown. And the question, of course, was how on earth do we deal with this if she doesn't engage with procedure? It was the main issue. The client was very worried about ignoring emails and just going off the radar, essentially, with her. But after trying to engage politely a couple of times, reaching out, offering support to her through, they had a helpline, they wanted to send her to occupational health, refused to do any of that. We said, right, you're an employer. Remember that. You're the employer. There's only so much you can do. You're not her entire support system. She signed off sick. You've made the offers that you genuinely wanted to do. You don't have to reply to all these harassing messages. Remember that. And they told her that very politely and said, we want to discuss this with you, but through the right channels. If you're too sick to engage, we absolutely understand. We want to give you the time to go and get better. And that diffused the situation because they set the parameters, they followed the processes, try to implement them, but you can't force somebody to go through that with you. And then eventually, to be honest, there's loads more to this story, but eventually she was off for so long, we instigated the capability procedures because there was just no way she was going to be able to return to work. It was very, very difficult. And it is one of those situations where actually you want to do the right thing. You have your procedures, but you can't always get the employee to engage. So this was where we said to the client, as long as you do everything you could reasonably be expected to do and offer the support, try and have those conversations. If the individual doesn't engage in that, you can't force them to. So go back to your procedures. If they're off sick, it becomes a capability. And this is one thing I would reiterate to people. This one started as a suspension. It very quickly moved into capability, potentially disciplinary for different things she was doing throughout. Don't be afraid to engage in the different procedures just because somebody has got poor mental health. It's about knowing the right time to instigate the right procedure and the right issue to make sure you get the right reason for the dismissal at the end, if it ever reaches that stage. And then the second one was an individual who basically accused their line manager of stalking them. And I'll just very briefly talk about this because it highlights the impact of having the right conversations in the right way but following your procedure. They were clearly illogical, saying their manager was logging into Teams meetings using their son's TV IP address. I mean, I don't even know what that means or what the individual thought. And they were accused of leaving nails in the car, and they lodged grievances about it. And the employer said, well, what do we do about this? They've lodged a grievance. Hear the grievance. Ask the individual if they're okay. And they had the conversation by going, these are obviously really serious allegations. Are you okay? What do you want to do about this? These are people you're working with day to day. So do you want to take some paid leave? It was technically, if you were arguing it in a court, a medical suspension, but you've avoided that trigger word of suspension with the individual by just saying, look, this is obviously difficult for you. While we investigate, do you want to take some time, paid leave, but it's your decision. So you're having the same conversation following the process, but in a way that hits softer with the individual who's clearly going through acute issues. And And this one, actually, obviously, the grievances weren't upheld, these things weren't happening. And the individual did resign and said, obviously, I can't come back. She'd come through the mental health condition, but she didn't want to return. And we offered her all the support and usual processes at that point. So it resolved. But it's sometimes the conversation, you follow the process, just have it softly. Because if you go, you're being medically suspended, all people will hear is the suspension. They won't hear anything around that. So I just kind of wanted to highlight those real life examples that were horrible to deal with. But actually we navigated both of them by going back to procedure, having soft conversations and knowing the grounds and having confidence in the decisions you were making at the right point. And this is the point, and I know Natalie and I were talking about this the other day, don't ever be afraid to ask the individual if they're okay. It's the starting point. It's an into the entire conversation. Like you say, you get to know your staff. So if they're quieter when they're normally louder, just ask if they're okay. They don't have to open up to you. But again, if you're doing that, you're showing that you care. It's an inclusive environment. You owe a duty of care to all employees. So at the very least, you should try and have that conversation. But remember, in those situations, so the two I just went through, the people being accused, that was horrible for them. And you owe a duty of care for those individuals as well. So make sure you don't forget those that are on the receiving end of the treatment and they get the same support that you offer everybody. Otherwise, you might unwittingly end up on the receiving end of a poor mental health long absence claim and issue from that individual as well. You're the individual's employer, not their entire support system. And I think human nature, you tend to get embroiled, particularly in small, close-knit teams. Like the first example we spoke about, the individual who, basically the manager who was on the receiving end of all the harassing emails, was a friend of hers, but would respond to things through work emails, even though we'd clearly said, don't do it because it's blurring the guidance. She's brought a grievance against you at that stage. Why would you talk to her? Yes, you care about her, but we've got to stick to employer process and the right support at the right time. You can't be their family, their medical support, their everything. You're the employer, and there is a line, and you can unwittingly get yourself into difficulties if you cross that. Remember your basic processes, occupational health, counselling, mental health first aiders, use them, signpost individuals to them. And risk assessments, I really want to highlight this because this is so, so useful when dealing with neurodiverse conditions, stress at work, poor mental health, however it manifests. Health and safety individuals can use these, but actually the Health and Safety Executive website is brilliant and it will talk you through as an employer how to use these assessments. It will go through and it basically forces you to have an open conversation with the individual to identify the triggers and the things they perceive are causing the issues in the workplace. So sometimes it's not that helpful and you think, well, that's just a performance process, but you can gain not only putting the right support in place for the individual, but you can actually sometimes see where the risk factors are going to be if they do bring a claim later on down the line. And it gives a structured approach to, okay, that's the stress identifier. What is currently being done to support them? What could be done, by who and by when? So it really sets out that support approach. And a lot of those things will be your reasonable adjustments as well. So occupational health are often saying to people, carry out these stress risk assessments. So if you haven't got familiar with them, absolutely advise that you do. And just to remember, you can't force somebody to admit they have poor mental health. So the questions that were coming in earlier about, well, we've offered all the support, we've done everything, and they're still saying, well, it's almost the opposite, actually. They're still saying, I've got a poor mental health condition, it's because of X. You're an employer, you can only do so much. It's reasonable adjustments. It's not every adjustment you could possibly think of under the earth. Always remember that. And I think with neurodiversity, stress at work, poor mental health, employers forget that and they think they can't make that final decision to dismiss somebody because somebody is just shouting that they have this condition. If you've done those supportive conversations, you have that inclusive environment, you've gone through these processes, you'll then naturally have your written evidence trail. You're going to be in very, very good position if they do try and bring a claim. And ACAS are very good at supporting that through the early conciliation process as well. So remember your process, have confidence, like we were saying before, and then you're going to be in good stead. Yeah, and this is kind of what we were saying earlier about reasonable adjustments. It's support reasonable adjustments. If they don't acknowledge that they're poorly or have a disability, you can only support them. And that support will 9 times out of 10 equate to a reasonable adjustment. We've kind of gone through as well, if an individual takes advantage, if you do provide that support, you're immediately taking away their argument of, but I've got this condition, because you can immediately respond with, well, we've had the conversation with you, you've gone to occupational health, we've done the stress risk assessment, what more could we do? So that's the position I kind of want everybody to think about. It starts with EDI, and when an issue comes up, you want to be able to say, what more could I do? And it's kind of the bookends of the process. I don't know if, Natalie, there's any other practical gems you can add?
No, I think the one thing that we come up against regularly is about a situation where the manager just says, don't worry, it's going to be okay. And this is usually when there is an issue, but they are nervous about approaching the issue in the first place. So it could be due to that disability, it could be the reasonable adjustments, and they're often put by having different conversations, and they do get treated in terms of the conversations. They need to be treated as individual. If you have an issue with their performance, discuss their performance. If you have an issue with their absence, discuss that absence. There's a question that I want to bring up. So if someone was on sick leave due to a disability, would this have to be paid, or are we okay to follow our normal sick pay procedure? Absolutely, follow the normal sick pay procedure, SSP. If you then start to treat people more favourably, and you're not aware of somebody else having a disability and they've just been off for X amount of time for something random like a cough or a cold, they say, well, actually, you're treating that person differently, but I'm disabled too. So I always suggest sticking to your normal sick pay procedures, unless in exceptional circumstances. I know unfortunately, we've seen an increase in cancer diagnosis. So a lot of employers are being sympathetic towards that and are paying in accordance to that. So hopefully that helps answer that question. But yeah, whatever you do, just don't overcommit and end up doing what my client did behind my back, which I'm still aggrieved about, Tessa, because it could have saved so much hassle. Don't put in things that you're not supposed to put in. Always get the medical advice. And if you're not sure on conversational advice, speak to somebody who does know how to structure that conversation, and you can work together.
Exactly that. And I think the last slide so neatly lends into that. It's procedure, procedure, procedure. Don't treat people differently. Use it as the backbone that runs through the conversations. Make sure the individual understands the procedure. So then when it gets to that end point, they've been warned that actually there's not much more we can do. This might lead to termination. It's there in black and white. Have that confidence to follow the procedure, get the medical evidence. And 9 times out of 10, if you've started the whole issue with basically saying, are you okay? What can we do to support you? Everything, the chances of it escalating into all these scenarios that we're talking about and people are worried about, it's so much less. The risk just naturally disperses because you are an inclusive employer. You've had those conversations, you've put the support in place, and you're rarely going to be in a position where, touch wood, you'll have a disability discrimination claim against you that you can't defend. You'll never be able to stop people having a go and being affronted and just having that type of personality. That will happen as an employer, but you just want to be able to say, hand on heart to the judge, what more could we have done? And your procedures are always your guiding part for that. Just very briefly, deliberately misleading a company and providing false information can be a disciplinary offence. And this has come up before, where people have pretended they have diverse conditions or mental health, or are taking medication that means they can't work on certain days. Like I said before, don't be afraid to actually interchange between policies and procedures at each point. They do interact with each other.
Thank you, Tessa and Natalie. I can see that time really has flown today, but if you'd like to share any final thoughts with everyone today, that would be wonderful. And anyone we didn't get to your questions, please do feel free to connect with Tessa and Natalie on LinkedIn, or I think Natalie's even kindly provided her phone number. But yes, please leave us with your final thoughts.
Yeah,
I think. Oh, sorry,
you
Tessa.
go first. You go first, Natalie.
I was going to say, I've had a quick, brief look down the comments and the outstanding Q&As. There's a couple of people that I'd really encourage, if they want to give me a call, I'm more than happy for them to nip onto my website, which is reboxhr.co.uk, and you'll find all my contact details on there. I'd really like to try and help people if I can, especially if you've got something that's pressing or you're feeling a bit nervous about approaching. So don't feel that you can't reach out to me. You're more than welcome to speak to myself or my colleague Faye in the office. We're here to help.
Yeah, and likewise, all I would encourage people to do is don't be afraid to grapple with the issues and face them head on, have those conversations, and then you'll just find yourself in a naturally, everybody will feel more relaxed about dealing with the issues. You will naturally create that culture that you want in the workplace, avoiding having to speak to me to defend a claim at the end of it. So yeah, just don't be afraid, have the confidence. And at any point, do lean on your advisors for support. It's what we're here for. We see the issues, so over time we develop more and more strategies to deal with these type of situations. So use your network, use your resources, use the medical evidence, and you're going to be in safe grounds.
Thank you both so much, Tessa and Natalie, and thank you everyone for joining us today as well. I think today has been so brilliant that if anyone is interested in a part 2, yes, I'm springing that on Tessa and Natalie right now, please check out the survey that will pop up at the end of this webinar once we close it down. And please feel free to share in the feedback if you'd like to see a part 2, because I'm sure you agree they've been absolutely brilliant today. And just finally, for anyone who is thinking about the general election coming up, just to change topic, we will also be holding a live Q&A on the 10th of July. There's a link on the top right in the resources. So if you have any questions about post-election, what's happening, please join us. And for that, you can connect on the link. Again, thank you everyone for joining today. It's just been brilliant. And Tessa and Natalie, a huge thank you to you both for your time.